I understand that you have a theory of damages, a claim which says, this was going to be a long-term relationship. It's not only governed by that piece of paper, and you made a projection of what your sales would have been, particularly not involving Chattawa, under conditions that you would have anticipated. And that is the thinking that informed your $1.6 million position. I want to look at the damages that would flow from your other legal theories.
Mm-hmm.
Okay, so let's just look at the contract piece just for the moment. MedPro would point to the sales figures,
Mm-hmm.
and we wouldn't be able to show any involvement by Cho, so it would just be from Chattawa
Mm-hmm.
and stuff. And they would say, looks like there was cause for termination, and looks like this. So the worst case is nothing.
Correct.
Right? And you're just saying you don't think that's going to happen.
No.
Okay, that's fine. But when I say worst, it's
Mm-hmm.
worst.
Mm-hmm.
But then you're saying that the 90 days is your most realistic worst.
I think so.
Okay,
yes.
well, let's talk about what that would be. Assume for the moment that you had a situation where the court said, well, no real cause or not sufficient cause invoked, and so under this contract they had a 90-day termination provision. What would the damage, what would you be owed?
The way we would look at it is that if we would have a reasonable expectation of about $33,000 a month profit.
And you're getting that from the year with
from
the
our
800
prior year sales figures of $800,000.
And you get gross profits out of that of $400,000-ish.
$400,000, that's correct.
And if you divided this division,
That's $33,000 a month.
Okay.
And if we had 3 months on the contract, that would be approximately $100,000, and that's just on the contract termination claim.
And you'd cover that. One of the ways they came up with the 60 was by saying, well, they don't like using the 800 because it was the best year. They understood not using the 400 because of the Chattawa problem. So they actually looked back to the 500 year, by which time, which was the year before the 8, by which time you'd been in the market for a little bit. If you use the 500 figure, that's $250 gross profit, 20 a month. So that's 20 a month. That's where they came up with 60. Okay. Do they have? I mean, right now, it's it's about almost about a year from the time that you got that letter. Could they send you a letter tomorrow saying, now we're going to do it right, and we're deciding to not renew as of the September 1st. If they did that, what would your...
Well, we'd have 14 months then, 14 months of damages.
Okay, so if you had 14 months of damages, if we do times 33, that's...
That's 460,000.
460, and if it was by 20,
we
that
use
math
their
is much
figure,
easier.
20,000, that's 280,000.
Okay, so let me ask, I know, if a court just limited you to the contract, to the paper, I know you don't like that part, but if they did, if an American court did that, is the 460 your best case?
On the contract?
On the contract.
I think it is.
And there's a range that goes between 60...
I'm understanding little.
Okay. There's a range then. If it's 90 days, it could be as low as 60 to 100. If it's 14 months, 280 to 460. So there's a range between 60 and 460. If the court just said... And zero. We forgot the zero. But if a court said, no, the contract, then I just want to make sure that we're figuring the numbers the same way.
I think we are.
Okay. All right. That's helpful. And I do get that that's not what it was about from your perspective.
It's not making me very happy to see that.
Well, that's why I actually want to make sure you agree that would be reality if a court only went to the contract.
Only looked at the contract claim and then looked at the profitability differently than we would be arguing.
All right.
So there's a lot of variables in there.
Yes, but we were thinking profits over a long time, no?
Right.
Yes.
Right. And those are the things that get you into the $1 million range. Legal issues aside just for a second, can you tell me how has the probe and oximeter business been in India over the last, since you terminated Mumbai?
Well, our view is that Mumbai has actually really sabotaged the sales strategy that we had for India. That it was, it's not just that the sales have not been zooming, but that there's been active misconduct.
So there is a
With
legal issue there.
Yeah, and that
Okay.
has obviously affected, it has had an impact on the kinds of sales we're experiencing.
Right, I mean, what they've done is they stocked up, basically, knowing that they were going to get cut off for not having enough sales. Where they could make sales, they made sales. And now we can't go in there and sell our product to anybody because they're all stocked up.
Let me ask, I know that when you terminated their contract, or maybe not too long after that, when you terminated Mumbai's contract, you did offer them the opportunity to be a non-exclusive.
Yeah.
But I understand that that hasn't happened because of whatever, that hasn't happened.
They turned around and...
If we could undo the unpleasantness, assume they didn't sue you, okay? And you offered them a non-exclusive and they said, we're not happy, but okay. Would they be able to make sales here, to continue to make sales the way they were before?
the way they were before, I guess. The fundamental problem is that they weren't making the types of sales we were expecting.
I have another business question for you. How have you set up your business in other countries? In other words, is it typical? I know here you started with an exclusive, you've moved to non-exclusive, or wanted to move to non-exclusive. How have you done it? How have you done the arrangements in other countries?
Usually we've done it non-exclusive. That's the best way to do it.
How does it work? What do you have to do when you're going to a country that way?
Okay, there are a number of things that we have to accomplish. We have to make sure that people are getting trained on how to use this. So we may go to medical schools. We may have somebody go in and give demonstrations how the product works, sales pitches essentially on the product. But there are sales pitches that are aimed at reassuring them about the safety of the product so that we get approval to have the product used by hospitals. And then obviously it transitions into, once we get the approvals, into sales. Can we get people to buy the product?
Right.
At that stage, you really have to have either the non-exclusive people or our company putting in some energy, some money, some legwork. If it's decentralized, it's a lot harder. You got to do all these fractured sort of pitches.
So, depending on how centralized or decentralized, either way, it's a labor-intensive process. You have to, if it's a different country, you have to send people over there. You have to house them. You have to get people over there. You have to do the trainings on the before they purchase, then after they purchase. The reason I ask actually is Mumbai says that they spent, because it wasn't a non-exclusive, that this was their job to do.
Yes.
They spent somewhere on the order of $500,000 doing that work. I don't know if they've covered all of India yet, but does that sound, using that as a measure, does that sound outlandish to you?
No, that they could have spent $500,000. Yes.
Okay.
But they are in profit mode now.
yeah.
Just to be clear,
Right.
their sales to date with the slow growth that we're so troubled by has already put them into profit.
Above the,
Yes.
they've
That's my
expended.
They should have gotten a lot more. If they put in $500,000, they should have gotten a lot more out of it than they've gotten. But yes, I can believe they put in $500,000.
Okay, all right. One way to think about money that you would pay to Mumbai is not as, I'm settling a legal claim, I did something wrong, that's is to say, well, you could think of it as, because they were an exclusive, it was in their interest to be the ones that spent the $500,000 because they were going to reap all the upside later. Now we're going back and saying, well, it's going to be a non-exclusive, and if you'd done that from the beginning, you would have had to bear that $500,000 expense.
Are you suggesting that we pay them $500,000?
No.
Okay, good.
I don't think that's going to be necessary.
Oh, okay.
But here's what I am suggesting, just a way to think about it, is that if you did, or less than that, whatever amount you pay that's less than that, you could think of it as, a reimbursement. You would have had to pay it.
Right.
Someone's got to pay it. You could think of it as a reimbursement for having to put in that upfront investment, because now the folks who are the non-exclusive distributors after that benefit
I understand what you're saying. I appreciate, that we could recast it as kind of a research development front end
Yeah, that's what I'm
cost.
thinking.
But the bottom line is it's way too big a number.
Thank you for waiting. It's taken a little while because I tried to convey to Mumbai some of the issues that you raised. And I do have a new offer from them. They were at $975. They've come down to $875. Well,
It's nowhere near realistic. That's not a significant move.
well, it is $100,000. I understand that they're not yet in the range in which you could seriously consider a settlement, but my experience is this is the process. We're a good deal away from the 1.6 million that they were before, and I think they understand that this isn't going to solve the problem. And yet, it's part of a process, so I do need another number from you, I think, to respond to them, so that then I can go back to them and suggest that some more movement is needed.
I think we could go to 140. That's where we're comfortable, given the circumstances.
Okay, so it sounds like you're thinking that the most likely exposure, if there were any, would be for the 90-day termination, which would be on the order, and as you computed, of more like 60 to 75,000. Some concern about maybe a 14-month exposure, and as you average it, that's how I would explain it to them.
Yeah, that's our reading of the contract. That's about where we're exposed.
The mediator suggested that MedPro make its next offer $160,000 rather than $140,000. He stressed that a move to $140,000 would represent only a $20,000 increase from MedPro's last offer and might discourage Mumbai from compromising further. MedPro resisted the suggestion, and the mediator took a different approach.
Where would they have to go for you to be comfortable going to 160? I know it's not 875, but the question is, where would they have to be? What kind of signal would they have to give you for you to say, okay, we can go there now? It's not, doesn't mean we're going to where you are, but at least we're in the right range.
Not 875. Let me just.
Yeah, it's okay.
I would say if they came in at 250,
Okay.
somewhere in that range, we could reframe this.
This would give you a place from which the further compromises could come that might get this to something that you could realistically, essentially explain to the company.
Yeah, that could get us to be able to counter with 160, but not 2. We're not going to 2.
Okay.
Just
No, I understand.
don't want to.
So, I'm not sure whether I would want to explain this to them or not. I don't know if they're ready to hear a number like that, but if and when they are, would it be okay for me to explain that that's the range in which you think then the future bargaining has to happen, as opposed to where we are now?
Yeah, I think we're
Okay.
comfortable sharing that.
Okay. So, I've talked to them. They see, I think what's happening is they're seeing their primary exposure under the contract as being the 90-day termination. It could be, they say, 14 months, but they think more likely about 90 days. And they've got the lower profit figure per month than you compute. So they've gone to 140 from where they were before as their next move.
140.
Well, that's where they are now.
Do they understand this is a good faith process, Dwight?
Yeah, I mean, this is ridiculous. We moved down $100,000 and they've moved up $20,000. It's completely insane.
I think the problem is that they're seeing your 875 as being considerably higher than you could recover under the contract, even under a 14-month termination.
In our view, there's a much more realistic number where they should be at this point.
Where do you think they should be?
I would say at least 400,000.
If they were at 400 with a non-exclusive arrangement continuing in the future with appropriate guarantees, where would you be? If I could get them to 400, just for my private information, this isn't, just for me to know.
Give me 1 second, please.
Sure.
Yes. Yeah. I think we would be at about 650.
Okay. All right, well, that gives me a sense of what the range needs to be from Mumbai's perspective.
Which, by the way, is a number that is a huge concession from where we started and a huge concession from where we started this conversation with.
If I think it's the right moment, would it be permissible for me to indicate that, from your perspective, that's the range in which this bargaining should be happening?
If you're going to throw those numbers out, it has to be with the understanding that the 400 is, we're talking about bottom end of a range, and where we're really realistically at is close to the 650.
Sure. I guess what I would say to them is that you've sent the message that in order to get you to 650, they'd have to be at 400, and you haven't seen it, and therefore you're not anywhere near there.
That's a much better way of conveying the message.
Okay. Well, I'll try to be very clear about it.
Have you folks ever heard of something called decision analysis?
Yes.
No.
I don't know that.
Okay, but I think I remember from your background that you had some math.
I know very good math.
Very good math. Well, I don't even need very good math here. I just need arithmetic. Let me tell you what the logic is and how it works.
The mediator gave a simple explanation of decision analysis, then turned to how the process could be applied to help parties make decisions about legal cases.
And the idea is to say, well, most of us like to think that we take what's going to happen, we discount it for the risk to figure out whether we should go one way or another. Is that making any sense
So
to
you're
you?
saying look at probability.
Yeah, that really is what I'm saying. I'm not, by the way, saying that you have to settle a case on the numbers that come out of this, but it's a way of thinking about it. In a way, it's, if you were a computer, which you are not a computer, this is how a computer might go about looking at this, okay? If we were to finish discovery, what would happen next? There would be motions. What are the motions?
Probably a summary judgment.
Okay, so they're going to file a motion for summary judgment. You know what that is.
She has explained
Yeah,
to
we've
me.
talked about it.
Okay, and my sense is he would file a motion for summary judgment on the longer term part of this.
Correct.
Not on the
Yes,
written contract
right.
part. Okay, so the first thing that would happen is the summary, before trial, the summary judgment motion would be heard on the issue of the longer term, I'm calling it, right? The larger damages piece. And summary judgment could either be granted on that piece or denied, right?
Right.
Right, okay. They could find cause, and if they find cause, you're done.
Right.
Okay, no cause. If they find no cause, then what?
Then we would look at the other grounds for escaping from the other escape clauses from the contract, the 90-day termination.
Well, then they could find yes, but it was a 90-day termination.
Correct.
What I'm interested in knowing from you is what percentage risk you would put on these things. So my first question is, what do you think are the chances that you get by summary judgment, or that they win summary judgment?
On the future.
Just on the future
issue,
part, yeah. Mhm.
We've talked about this, Shalini and I have talked about this, and I think there's a fairly high likelihood that summary judgment on that issue could be granted.
Would you put it at 90%?
Reluctantly.
I'm asking.
High,
Yeah.
90% high.
Okay.
Yeah.
All right. Well, let's just see. We can, one of the things about this is that we can always fiddle with it. Okay. Notice how these two things have to add up to 100, right? Because those are the two things that can happen. Win, granted, not granted. Okay, so now what do you think are the chances that they find cause?
I think realistically very low.
There's no cause.
10% at most.
Well, their argument is that the sales went down. They didn't make the sales go down, and that was cause, and they kind of sort of talked about it in the letter. I don't think so?
No. I think variable sales in a situation that young is predictable, and I do
No
not
cause.
believe that's cause.
And besides, the original contract didn't set specific
No,
sales
it did
dates.
not,
Okay.
nor did the letter allegedly terminating the contract allege cause or describe what the cause was.
Okay, so what percentage would we put on that one?
I would say not more than 10%.
Okay, what's good for the goose, right? Okay, so 10%, so no cause, but let's look at the 90-14. What do you think are the chances that they cap the damages at the 90-day termination versus the chances that they keep it at the they take it out to the 14 months?
I think the 14 months is a more realistic likelihood, and I would put it at more than 50%.
Would you do 60-40?
Probably, yes.
Okay. Okay, so the way this would work, if I had a computer, you could flick a button, like TurboTax, and you could do it. But the way you would figure this out is you would the way you would do this then is you'd roll it back, you'd discount it back, and you'd say, well, 460 times 60% is 277. 100 times 40%, that's an easy one, is 40, right? We would add those two together. I can explain why in a sec. Well, what you would do is you say, well, there's a 40% chance of getting $100,000, that's worth $40,000. There's a 60% chance of getting 460. We said that was 277. You would add those two together because together it's sort of like a blended average. It's like a weighted average of the things that could happen.
These numbers are looking very bad.
Very bad. Yeah, I hear you on that.
I did not know I was coming today for math. I thought I'm coming for mediation.
Well, let me just say this. If what this is suggesting is if you leave the mediation and you go forward to trial, these are the way that your lawyer would look at the risks and what might happen at trial.
It's very bad.
Well, if it's very bad, then that's actually why I would suggest that we look at what we can get on the table here.
I have to talk to my lawyer about this because I am not agreeing with these numbers.
You're not agreeing with the percentages that your lawyer put on them, or you just don't like the way they come out?
I don't like the way it's coming out.
Yeah.
I very much trust my lawyer.
Yeah. Well, I mean, I have to say that I don't blame you for not liking it. The real problem is that
yes.
That's the
yes,
problem.
because I was thinking it's something very different.
Yes.
And I was expecting something very different.
I hear you on that.
And this is very disappointing.
Well, and the other piece of it, which I hate to add, insult to injury, is that you realize that this doesn't even include the lawyer's fees, because in the American system, you pay your own lawyer's fees. So even if you won, say, $460,000, you have to back out of that. I mean, you have to pay something to get that. So it's actually worse than this if you were to go forward that way, which is why, look,
it cannot be this bad. Why they would offer if it's this bad?
You really want to know?
Yes, I want to know.
Okay. Well, I don't know what's going on in their heads. People have all sorts of business reasons for wanting to settle cases. Sometimes they don't want to have their executives tied up. Sometimes they actually feel bad. I mean, look, I think the argument that you made that you had invested money in marketing and things that they would have otherwise had to do themselves, I think that had some power with them.
I explored a couple of possibilities with them. One is what we might call range bargaining. The idea being, could we agree on a range in which the bargaining would happen? I asked, if you move to a certain place, where would they move? And obviously you would have to agree to move there, and they would have to agree, but what they came up with was that if you were willing to go to 400, they would be willing to go to 650. And I didn't indicate you were willing to do that, but they were not happy, let's say, with the idea that they'd gone down as they saw it 450 and you'd come up 20 to 140. Well, I understand, but that was the context.
It seems to me that they're just not getting it in terms of a realistic appraisal of the case.
So,
and in terms of the range bargaining of 250 and higher, I just don't want to go there. It just seems to me clear what will happen from that point.
Okay. Well, I said I would ask, but I didn't give them any assurance that you would agree, and there we are. There are various possibilities here. One is you could make another offer. At some point, I suppose, I could try to give some predictions about my estimate of what a jury might do with some of this. I think it's a little early for that because it tends to freeze the bargaining. There are other things that could be done, but they really involve me taking much more of a role in this than I'd like to, as long as we're still moving somewhere. But there is the question of where really we're moving to. I think there's some strategic maneuvering going on. Maybe a little bit on your side because you have to, and maybe on their side. One way of cutting through that sometimes is what we call confidential listener. The idea being this: I would ask you and them confidentially for your, what I'll call your next to last number, the point at 5 or 6 p.m., not your final offer, but the one just before your final offer when you'd say that's it. Having gotten them, I would bring in the two lawyers and I would tell them in the same time, in the same voice, a verbal statement of how far apart you really are. I wouldn't give you a number because then you could just calculate what their number was and they could calculate yours. And that would give you some sense of what the real gap is. So you both have to agree to do that. It doesn't mean you're committing to any specific new offer, but it gives you some new information.
You won't share the amount of the
No,
gap, just to
not without your-
characterize it as small, medium, large, extra large?
That kind of thing. I will not without your assent. And I wouldn't disclose theirs to you without their assent.
Well, I think there's value in knowing how truly
Okay.
far apart we are.
Mumbai agreed to the confidential listener process and told the mediator that its next to last number was $550,000. MedPro gave a number of $170,000. The mediator then met with both lawyers.
I've gotten from both of you a number, and let me say where things are, and it's not either one's final number, so you're going to have to make some adjustments in your mentally for that. There is a significant difference between you. It's going to cost as much or more, maybe a lot more, to litigate this case. So given the range of the gap, and given the cost of litigating, we're talking, as far as I can see, of taking depositions in India, reviewing 5 years worth of business transactions on both sides. For all I know, a trip to China, let's hope not. And all the rest of the things that go into litigation, including, I've been told, motions are going to be filed inevitably and have to be dealt with. I think it's worth continuing to work on this because you're in the range where it really makes sense to settle. But I can't tell you you're $25,000 apart, and I can just suggest splitting the difference. We have